Okay, good afternoon, everybody, and welcome to LAW2022 Online, Residential Property Shape the Debate, sponsored by Move Reports UK, with me, Mike Giorgio, David Keeley, and Richard Snape. In this live version, you can put your questions to David Keeley and Richard Snape and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. So to introductions. Like I said, I'm Mike Giorgio. I have been in the property information and tech side of the business for over 22 years. Originally on a scooter all over London from council to council conducting searches. Now I am more office bound with two roles as the Southern Director of Move Reports UK, directly looking after clients in London and the South. I'm also the Managing Director of Navro Compliance Limited, bringing simple to use tools such as the LC5 Lender Check product and ART, an automated report on title tool that has been said to change the way people work. David was admitted as a solicitor in 1982. Until his retirement from full-time practice, he was a partner in and head of residential property at a legal 500 firm. He now uses his extensive experience and understanding of practical conveyancing to cut through the academic niceties and make things relevant for the busy practitioner. He is a contributing editor to the Law Society Conveyancing Handbook. As part of LAW2022 Online, David's sessions include Residential Easements Update 2022 and Reporting to Lenders, What Are the Obligations 2022. Richard has been head of professional support at David Jones Board since 2002. He speaks at numerous courses for law societies all over the country, various public courses, in-house seminars with solicitors firms, and has also taught extensively to local authorities and central government bodies. His areas of specialism include both commercial and residential property, in particular in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. As part of Law 2022, Richard's sessions include inquiries and how to respond to them, leasehold dwellings, update in the light of recent statutory changes. So to kick off, we'll start by addressing some of the pre-submitted questions we have received from you. So I think the first question's directed to you, David. Do you think it is possible for a right-of-way to cease to exist simply because it hasn't been used for some years?
Essentially, no. I think a right-of-way. There's a case which was in my session, which basically suggested that abandoning a right-of-way is virtually impossible. In reality, if it's not being used, something's not being used, then the likelihood is that easement has simply gone into abeyance. It's sort of been suspended, but it hasn't actually gone away. So it could be reinstigated, reintroduced by removing whatever the block is. I mean, in the notes that accompanied my talk, I mentioned that one of the issues was that the right-of-way, which in question in the case, had been blocked by a fence, which the people entitled to the right-of-way had deliberately put up. And it was claimed that by doing that, they'd abandoned the right-of-way. Well, the court said no, they hadn't. They'd simply put it into abeyance, and then as soon as they took the fence down, it immediately resurrected itself. So I think you can't assume that an easement has gone away simply because nobody's using it. I think the only way to know that it's stopped completely for certain is to have that easement surrendered, or for it to be it rendered ineffective by buying both the dominant and servient tenements. But no, essentially the answer to the question is no.
You remember that? Did you talk about? Remember Ben and Harding from the early 90s, where they hadn't used the right?
No, it was. Do I remember it? Sorry.
Yeah, where they hadn't used the right of way for 175 years, but it hadn't been abandoned.
Yeah, indeed. I mean, that was the more recent case was the one I covered in the session, which was. Hang on, I'm just looking for the name of the case to remind myself. It was Annetts against Adlai in 2018, which basically followed the same principle. So effectively, I think the answer has been for some time. No, you can't simply lose it by not using it.
It's also the land registry will not accept it. The only thing they'll accept is an express surrender, really, like you said.
Effectively, yeah.
And even then, it stays on title. It just has a note to the effect it's been surrendered. But,
Agreed.
Okay, lovely. Next questions to you, Richard.
Mm-hmm.
When did the Building Safety Act 2022 come into force?
Oh, my favourite piece of legislation, 262 pages to plough through. It's some of it's already in force, and some of it we haven't got commencement dates for it yet. It basically received the royal assent in April 28th, and the legislation itself, much of which is sort of marginal to conveyance, it must say, but said that some pieces of legislation will come into force 2 months after the royal assent, which is obviously June the 28th. And they're up and running. Basically, I'll tell you what they are. They've amended Section 1 of the Defective Premises Act, and that's now up and running. They used to have a 6-year limitation period to it, and now for any claim rising from June the 28th onwards, it's got a 15-year limitation period. It's got a 30-year limitation period, backdated for any defective workmanship on any kind of dwellings, not just flats actually, not just leaseholds, going back 30 years. I think I give an example in the notes. You could have a defect from 2010 and you've got a claim until 2040. They finally implemented Section 38 of the 1984 Building Act as well on June the 28th, but not retrospectively, which allows, if there's breaches of building regulations, anybody who suffers a loss, physical, mental damage to property as a consequence has got a claim for up to 15 years. And also the service charge caps came into force on June the 28th as well, which are quite convoluted. Lots of the legislation is not due in until well into next year. Primarily the concept of high-risk residential buildings. They've started implementing sort of backup legislation likes, but they're expecting that between April and October of next year. And there's masses upon masses of other legislation provisions in it, not really related to one another, all about building safety. So keep your eyes open.
Okay. David, do you want to comment on that, or?
No, I think, frankly, Richard's the guru on that one. So
yes,
I think
that's my life.
Yeah, can't disagree with it. Can't disagree with anything you said on that one. So
okay,
no
260 pages.
Lovely.
Yeah.
So
you read it, so I didn't have.
Okay, so we have a question from the audience come through. I think this is directed back to you, David. What would your view be if the right-of-way had been blocked by the servient tenement even, and no action had been taken for 12 years? Would the ability to enforce the easement be lost by reason of the Limitation Act 1980?
I didn't hear the question, sorry.
Okay.
It broke up, so...
What would your view be if the right-of-way had been blocked by the servient tenement, I'm having trouble with that word, and no action had been taken for 12 years? Would the ability to enforce the easement be lost by reason of the Limitation Act 1980? I'm
not convinced it would be, frankly, because the it comes back to the same point as abandonment. I mean, the easement hasn't gone away. I mean, okay, the Limitation Act is the time in which you have to instigate proceedings. I'm not convinced that that there's anything to take action for. If it's been blocked, then the same issue applies. It hasn't actually gone away. It's still in existence. But whether the courts would accept an application to say that it had been outside of the 12 years, I'm not sure it matters. I don't think there's any action there to be had, frankly. But Richard, you got any views on that?
I agree. I mean, I'm not sure that the 12-year period is relevant, but there have been one or two cases, but again, not the kind of thing I'd wish to accept, where there's been successful arguments of estoppel when you've built over the right of way or something, and you acquiesce like the right of way. Yeah. And there was that. There was Moore and Rawson, which is an 1820s case where they had rights of light. And knocked down the building with the windows and the light and rebuilt without any windows on that side, and that was sort of an implied abandonment. I think the possibility is estoppel, but if I was involved in the conveyancing process, I wouldn't want to rely on it. Yeah,
no, exactly. No, I think that's probably not an easy one to answer, to be honest.
Okay.
I don't think it would be a factor. I think I'm probably thinking the analogy with restrictive covenants. If you haven't, the Emmett on title and the lender's handbook says if it's not, if it's been openly breached for 20 years, then you can't take enforcement action. There's an argument under the Limitation Act that if you've openly breached the covenant for 12 years, it can't be enforced. I'm not sure the same would apply to easements.
Easements, no, I don't think it would be. Yeah, I agree with your concerns there.
Okay, thank you. Another question from the audience. Do we need indemnity policies for lack of building regulations and planning permission?
Well, yes, you need the Richard Snape indemnity insurance policy for both of them. That's a bit of a joke. The time periods for enforcement of building regs currently it's a year. One of the things the Building Safety Act intends to do is put the time period for enforcement up to 10 years. But the local authorities can actually prosecute for up to 2 years for lack of building regs. The people who get prosecuted are people who caused the breach, the contractors, the builders, not purchasers. A purchaser might have enforcement action. There is a possibility, albeit remote, very remote, that local authorities, they can get injunctions in relation to dangerous building, so like, without time limit. What Cotting Manati Bauer Jones was about. The chances of enforcement are not necessarily the issue. I've got to say the policies are so cheap that it's often the easiest way and probably the cheapest way of actually dealing with any kind of disputes between the parties, rather than waiting for spending loads of fee and time on it. Planning permission, I think, planning permission breaches, if it's building, mining and engineering works, is 4 years, and if it's planning conditions, it's 10 years. There is actually provision, this is not something I was talking about, but there is actually provision in the Levelling Up and Regeneration Bill, and people like Mike and David have to pay us poor Northerners in Cheshire your money, whereby the enforcement period for planning breaches for building work could go up to 10 years in England, not Wales. Again, it's more likely that there's planning enforcement, long term, well after a year, 5-10 years and the likes. And if you've deliberately concealed planning breaches, then the time period continues to run. I think planning permission insurance policies are a good way of dealing with things again.
Yeah, I mean, I think the fact that you say that building regulation policies are so cheap, in reality, reflects the risk, doesn't it? But there's also, what can't be forgotten, is that local authorities have generally signed up to the Enforcement Concordat, which basically means that the action they take has to be proportionate to the likely harm. So, the chances of them seeking an injunction for the fact that you've put the windows in without planning permission, or you've done something in the loft without the relevant documentation, sorry, without building regulations, or done some minor alteration of the property without building regulations, is frankly non-existent. But I agree. Yeah, I agree that to be honest, it's often easier just to say to the client that we can argue about it forever. You know, from a legal point of view, it's completely unnecessary. But frankly, yeah, throw 30 quid at it and it goes away. Isn't it? So,
it's there is provision in the Building Safety Act, as they do, put the enforcement periods up to 10 years, and we'll see what it's not enforced yet, but we'll see what knock-on effects that is. Also, on my LinkedIn post, I got a comment that somebody replied to one of my posts. They raised inquiry, please provide building regulations, for the extension, and the response came back, we don't need building regulations because we built the extension ourselves. So that's the other solution. But building regs if you build the house. Yeah. But we better move on, I think, on that one.
Okay. All right. So the next question's directed to you, David.
People claim that they need the policy because the lenders insist on it. But...
Breaking up, David.
David, you've frozen. I think I know David's from working out of a hotel foyer this afternoon, so probably his connection's been lost. Richard, I've got a question after David's. Give him a chance to log back in. Should we jump straight to that?
Yeah. Mm-hmm.
Okay. Until
I'll make it back. I'll try some of the questions myself, but yeah.
Okay. So the next question directed to you is: can you explain the new provisions on service charges?
Yeah, so I sort of alluded to them. There's the things that came in on June the 28th. And David should be back by the time I've gone through all this stuff. They're not easy to explain. I mean, it's in the Building Safety Act, and the provisions bear no relation to what was in the bill at the beginning of this year and going through Parliament last year. The government backpedaled quite dramatically at back in February time as the bill was going through Parliament. Originally, for high-risk buildings, which are buildings basically of 18 metres or more in height or 7 or more stories, there was going to be a provision for something called a building safety charge, whereby safety work could be added to, the cost could be added to long leaseholders, regardless of whether it was covered by service charge. That was so politically controversial, it was dropped. The new provisions basically say, in relation to safety, it's got to be safety work, not other kinds of work on the buildings. Basically, if you've got combustible cladding, the government say, I'm not sure it's quite this easy, that they will pay for the replacement in any buildings of 18 metres or more in height, or 7 more stories. If it's more than 11 or more metres or 5 stories, they will get the builders, they've budgeted the builders, and the builders will pay for the removal of combustible cladding and the likes. But non-cladding safety work, basically something which is likely to cause collapse or partial collapse of the building. Things like cladding, which is perfectly safe but falling off. The starting point is the government expects the developer to pay for it. If the developer can't pay for it, the landlords, if they've got a net present worth above a certain level, the more the landlords who've got money, they will be expected to pay for it. Otherwise, there's a cap of £10,000 period to service charge and safety work. If the flat is worth, this is only for 11 metre or more in height buildings, I should stress, but if the flat is worth £175,000 or less, or £325,000 or less in London, you won't pay for safety work. It's bizarre the way the government of, the legislation explains it, because everything sort of comes into effect, if you like, on February the 14th, Valentine's Day this year. And the property's got to, at least has to be in place by February the 14th this year. The property has to be, the property has to, well, it be your main residence, and you can have 3 residences altogether, but if you've got more than 3 residences, only your main residence will count. The important thing in conveyancing, you've probably had enough of this now, is that if the caps on service charge materialised on February the 14th, subsequent purchasers have the benefit, which I think should be an inquiry. Yeah. So that's basically it. Service charges. Doesn't apply to less than 11 metre high buildings. I've seen 3 or 4 story buildings less than 11 metres. I came across one in Haringey from a council house right to buy, council flat right to buy. It's only 3 stories and the roof needed replacing. And they billed £118,000 last year. So it doesn't benefit lots of people.
Okay. I think we move on to the next, or the previous question, which was David's. So in your recording, you rightly say that there is a long backlog at the land registry. Given that, how can I protect my buyer client against an easement being created by a seller after completion, but before registration of my client's purchase?
Okay, yeah, thank you. Yeah, apologies, my internet connection just dropped out. Yeah, in terms of that, the only way that you can be absolutely certain is to be absolutely certain. Sorry, is to make sure you get your application in before your priority expires. It's as simple as that. That once you're in and you're in your priority period, you're protected. In the case Baker and Craggs that I mentioned in the notes. The danger arose from the fact that the buyer's solicitors, for various reasons, allowed the priority period to elapse by not replying to a requisition. So essentially, the lesson from that is get your applications in before the priority period expires. Now, I have to say I've got a bit of a concern about this moving forward with the AP1. Which at the moment, if, for example, you've got something, you're waiting on a restriction certificate or something, you can bung the application in knowing full well that you'll get a requisition, sorry. Under the AP1 system, you won't be able to lodge the application without that particular, for example, missing restriction from a managing agent or a certificate from a managing agent. So that might give rise to a few issues. And people say, well, I'll just renew my priority search. Well, you can't renew a priority search. You can get another one, but you can't renew one. And so, effectively, if in the instant, the fraction of a second before your old one expiring and your new one coming in, if somebody's waiting in the wings, they'll leap in ahead of you. So it's basically get your applications in before the priority period. I'm not sure there's an answer to how we're going to address things with the AP1 system. As I say, it's designed not to allow you to submit an application unless you've got absolutely everything. So that's a worry, that particular part.
Okay.
Yeah, it's one of those problems that thankfully it doesn't cause problems on a regular basis because no one knows it's a problem. But I've come across so many people over the years who think if you have to renew your priority search, it's just an extension of the priority searches. It isn't. It's a brand new search, and anything that's happened in the interim will be binding on you. But I think we're getting ourselves into a real mess in relation to easements, not least of which because easements are rights over other people's land. And
I don't know if the land registry have the land registry proposed to address this. When I mean, for example, if you've got a managing agent that's just taking forever to reply to a request for a certificate of compliance, at the moment, say you could deal with that quite easily, but under the e-system, I'm not sure how you can. It's as you say, the issue doesn't arise very often, thankfully, but
it probably arises a lot, but people are just none the wiser.
Exactly. No, I mean, the question of somebody leaping in and creating a new easement doesn't arise very often, but people not getting their applications in before the priority and then thinking they're protected by getting a new search is very common, but very wrong.
Okay. Next questions to you, Richard. should we include additional inquiries in relation to service charges?
I think, I don't know if David's heard anything as to whether they, because they amended the LPE ones, the leasehold flat management inquiries last November the 22nd, primarily to deal with the Fire Safety Act and also whether you can keep pets and you can have car parking in your flats. But I think they do need amending. I've not seen anything on the cards for the reasons I probably mentioned in my previous answer, actually. I mean, if you start to inherit the sort of the service charge cap from your seller, then you need to see how much your sellers already sort of have to pay for your service charge, quite honestly. And the 10-year time period is quite a long time. It actually stretches back for, you can claim 5 years before the legislation came into force on June the 28th as well. So I suspect that should be an additional inquiry. You'll start to annoy people if you start raising it. But I think it should be there.
So, yeah, I mean, it's a legitimate question. It's a question of, you'll get supplied with the information, but you don't always get the complete information from the stuff you get from the LPE1 is what it boils down to.
Yeah.
So I think just sort of parroting out inquiries, asking for stuff that you're going to get in the LPE1 is going to be is going to attract a withering response, I'm sure. But drawing out additional information which isn't covered by the LPE1, I think is quite legitimate. So.
I mean, the Building Safety Act has got other implications. They're not enforced yet, but I mentioned the high-risk residential buildings. They're setting up this body, part of the Health and Safety Executive. This is all post-Grenfell legislation called the Building Safety Regulator. And if you've got a high-risk residential block, 18 meters or more in height, with at least 2 dwellings or 7 or more stories, then you're supposed to register with the regulator. The plan is, although I don't think it's written in stone yet, for new builds, April of next year, and for existing high-rise buildings, October of next year. And if it's a new build block of flats, then 18 meters again more in height, then you're not supposed to allow anybody into occupation until it's been registered. Which that's going to be an inquiry, presumably, as well. Yeah. Now you actually prove that you've actually registered, because my client cannot move into the flat if they haven't. So there's a lot going on.
Yeah, indeed.
Okay. Next questions to you, David. My client has bought a piece of garden land from his neighbour. To get to it, he needs to walk over the neighbour's garden. There is no right of way in the TP1. Will a right of way be implied?
Okay. Well, the first point to mention here is that it sounds like your client's former solicitors, I assume, hasn't done a very good job. In fact, not getting a right of way to get to the piece of land that they've bought doesn't look to be particularly good conveyancing practice. I'm assuming that if that's the only means of access to the piece of land is over the neighbour's garden, then you might be able to argue, I think probably could argue, that there's an easement of necessity. But it's a situation that should never realistically have been allowed to arise, because it must have been people must have been aware of the fact that the only means of access to that piece of land was by crossing over land belonging to somebody else, for which right of way is needed. I suppose the other option, you might be able to argue that the seller had a sort of quasi easement, but I really wouldn't, which had converted into a full easement when you bought the garden. But I'm not convinced I'd want to rely on that. So I suppose it's if you can't get the original transfer document amended to incorporate the right of way, which perhaps should have been there in the first place, then probably best to try and work on the basis that the easement was implied.
Have you got your dog there, David?
No, not me.
We've got the office dog, guys. Let me just let him in. If he's not next to me, he's not happy. So bear with me.
If you hear a dog barking from my side, I'd be very worried, because I haven't got one.
Exactly. Yeah.
I think in those sort of circumstances, you shouldn't have to imply easements.
Yeah.
Something's gone tragically wrong if you have to imply easements. And necessity has to be absolutely necessary. Like you say, it's going to be landlocked. quasi easement into an easement, wielding and boroughs is a possibility, I suppose, and also.
I mean, the answer is to say it should never have arisen in the first place, and go back and try and get the transfer amended, because it's.
Yeah, you could claim Section 62.
Well, yes, I suppose you could do, but
again, I think in all those circumstances, I wouldn't want to rely on any of those. If I was a subsequent purchaser of that garden, at a later stage, I wouldn't want to rely on any of those. At the very least, I'd want a policy on that.
Effectively, or say even better to get the thing put right by what should be done in the first place. So,
Okay. Moving on, the next question is to you, Richard. Do mortgage companies require EWS1 certificates for less than 80-metre high buildings?
Well, this should take us until 2 o'clock. Yeah, it seems like we've been talking about EWS1s for years upon years, but they're only concocted at the end of 2019. And I wish the Royal Institution of Chartered Surveyors would just start all over again. I mean, the background is that it's post-Grenfell. It's not legislation. That's what sort of some commentators think. Well, couldn't the government just legislate against this? And it's not the case. If the valuer says to the mortgagee, "We want one," and the mortgagee says, "We want one," that's it. Originally, they were only meant for 18 metres or more in height, building 6 or take again. What really muddied the waters was back in January of 2020. Again, it seems like a lifetime ago when the government introduced this advice to building owners and multi-occupied residential, multi-story multi-occupied residential buildings, which said that it could apply to less than 18 metres high buildings. Mike's just lost his head. It could apply to less than 18-metre high buildings, and also buildings without combustible cladding, but something called high-pressure laminate. And it's been an ongoing dispute ever since. The RICS, the Royal Institution of Chartered Surveyors, amended their guidance in March of last year, and reiterated in certain circumstances it should be required for 3 or 4-story buildings. Then what happened is they reviewed last year the EWS1s, and on December the 10th, the review came out. I was amazed when I came across it later in the day, because they said that these things are a huge success, everybody likes them, and not my experience, and they're not changing anything. January, the now Department of Levelling Up announced that we don't think you need them for less than 18-metre high buildings, and withdrew their January 2020 guidance. But in March, the Royal Institution of Chartered Surveyors said you do. The valuers tend to listen not to the government, but to the RICS. The good news is that if you've got 2018 or 2019 in Wales building regs, you shouldn't have combustible materials. And also, I'm not sure if we're going to have questions, hopefully we will, on the Fire Safety Act that I was talking about. A lot of the mortgage companies and the Royal Institute of Chartered Surveyors said that if you've had a fire safety risk assessment that complies with the new Fire Safety Act of 2021, and you've done all the work, they won't require one. But I remember talking about this with David, sometime, was it last autumn?
Yeah.
And I suspect we're going to be talking about them again. Someday.
Again, I mean,
it's not
I think the interesting thing is that both the lenders, the UK Finance and the RICS, both in evidence to a government committee earlier this year, made the point that they think EWS1s are still required because they're a valuation tool, and they didn't differentiate between high-rise buildings and low-rise buildings. But the RICS did actually make the comment that they thought they applied more to high-rise than to low-rise. But again, we just wait and see. I mean, they're a valuation tool, so as long as the lenders want them, and the lenders seem to be saying we definitely still want them, then they'll want them for whenever they think there's a risk, I suppose.
Yeah, and 18 metres is quite arbitrary.
It is, yeah.
I mean, if the builder decides to build,
yeah.
They're not stupid. If they build 7 metres,
it does appear to be quieting down a little bit. And again, I saw some government research recently which showed that between two certain periods in last year, only 9% of applications for mortgages involving flats triggered the need for an EWS1. So maybe there's a slight quietening down on the lender's perspective. But
it's definitely quietening down, but I mean, they're here to stay for a long, long time.
I think so. We've got PAS 9980, which is still that's in development, but that will take over from the EWS1 eventually. But that's a long way.
That's a long way down the line. Because the other thing is that in England, building regs get amended again on December the 1st, and the approved document says that approved document B says that you shouldn't have combustible materials in 11 metre or more high buildings.
Right. Okay.
So it's the existing blocks.
Okay.
And I said we've also got all these sort of, no, we're a long time coming. The government's still consulting on the new building safety one. There's people out there who've already scraped together sort of massive amounts of, service charge liability, and don't get the benefit of any of these things, and they can't sell their properties. To some extent, the worst properties are the ones who don't need mortgages, because they're going to want the cheapest job possible and complain when their purchaser can't get a mortgage later.
It's I mean, the basic answer to the question is, do they require them? Well, yes, sometimes they do, because it's a valuation risk. So they just look upon it. If they consider there's a valuation risk, they'll want it. So
the valuers tend to err on the side of caution on these things. And so we'll have to see. But I think we will.
But as you say, when they repealed the consolidated advice note, the entire thing which underpinned EWS1's completely disappeared. So, and the RICS did actually say that they thought that the EWS1s had broad support from conveyancers. Well,
that's not my experience.
Not from me, not from me or any other conveyancer I've ever spoken to. But
I've talked to, and not from any surveyors either, quite honestly. They're also finding more and more people who have been doing the EWS1s who don't have any qualifications whatsoever to do them. With prosecutions under the Fraud Act. So, how far do you have to go to check that the person...
Perhaps we should do them in the quiet season for the lecture circuit, Richard. Yes.
There's no quiet season.
We know all about it.
No, the risks are too great.
Indeed.
Okay. Moving on, question directed to you, David, and one in particular interest to myself. How can I prove that I have reviewed a lender's Part 2 requirements and that all the requirements were met?
Okay, I assume this is arising from the CQS practice management standards, which actually requires that is evidenced on the file. And the answer is quite simple. I mean, let's hope, touch wood, that everybody has been reviewing their Part 2s every time. But the only way, the requirement for CQS is not only that you review it, but that you document it and you're able to prove that you've done it. So I think the only way, or a way, would be to presumably download a copy of the Part 2s into your case management and record in some way in the case management that those have been reviewed by a fee owner and that all the requirements were met. Now, one of the issues, of course, is that lenders change their Part 2s like people change their underwear. And so effectively, even though you may have done it when you get your offer, you've probably got to do it again just before exchange, just to make sure that nothing's changed in the meantime. And then double check and check it and record that check again. So it's, and the other thing I would say is that if let's say, here we are, roll forward, we're in 2029, and somebody gets a claim from a lender that says, we've repossessed, and we're going to sue you as the solicitors because you didn't comply with our Part 2s from 2022. How are you going to know what the requirements were in 2022 unless you've actually got a copy of it somewhere? Either stored on your case management file, or if you're still using paper, printed out. Because so I think like the answer is simply to save a copy somewhere and make a file note or an attendance note if you're in paper, or some sort of entry in your case management system to evidence that it has been reviewed on receipt of the mortgage offer and on and before exchange. And if any issues arise, that they've been reported to the lender and the lender's given you the okay. So it's, basically it's, the view of the courts is, from a solicitor's perspective, is that conveyancers are terrible at doing attendance notes and recording things. And if it's not recorded or evidenced on the file, the court's view is it didn't happen. So, make a note of it in some way, record it is the best way to do it.
Okay. Richard? Any input on this?
No, I agree entirely. I don't know if you have, Mike.
I have a lot. Well, basically, excuse the plug, but the NAVRO LC5 report, lender check report, is exactly created to solve this problem. So what the report does is it checks the part twos as they are at a given time, and then where the number comes in, the 5, it allows you up to 5 updates. So we advise a report is ordered on the day of instruction, and then at least, as David said, just before exchange, to do a refresh, and that will pull out if there's been any changes between your first report and the second one. And all this can be just saved into your file and documented. And that the problem with going straight to UK Finance is that UK Finance do not record what any change is. All they do is record the date a change has occurred. Okay, there's 104 questions in the part twos. You have to scroll through them all and decide which ones have varied between the last time you looked at something on there. This is what the LC5 does. So excuse the plug, NAVRO LC5, and that will solve your problems. Thank you. So straight on to the next questions, which is to Richard. How often should a fire safety risk assessment be carried out?
I've been mentioning fire safety risk assessments in courses since 2005, before the regulatory reform fire safety order came into force in 2006, and people have been asking me that on a regular basis, and the legislature itself and saying, obviously we've got amended fire safety, amendment for the Fire Safety Act 2021. It's as in when required. Terribly drafted legislation, and I didn't say who should be doing the risk assessment. The new version of the Building Safety Act said it's got to be a competent person, that the landlord is competent, they're going to employ a competent person. The guidance, which is available, basically says you should do a new risk assessment as and when required if there's a change of circumstances. So if you have a fire, then you'd have it in the common, in the flats, then you'd have to have another risk assessment. Or if you add to the number of flats or do sort of material work on the premises, you should have another risk assessment. But I'm not sure it's a lawyer's job to actually
know
those things.
It's okay. Our responsibility probably is to confirm to the client that one is or has not existed, but it's not for us to follow it up and chase it, as far as I'm concerned.
No, I don't think it is. It'd be nice in the way if it said that you have to have these things every year, every 2 years. We've actually got some fire safety England, not Wales, but England regulations coming in January of next year, which I sort of steered clear of discussing in courses because it's for the people who do the fire assessments. It's not for the lawyers. That fire doors have to be checked every quarter, and entrance doors every year. But I'm not sure that's our job.
Okay. Yeah,
there's a risk assessment and the work's being done.
Yeah, agreed.
Okay. Next question's directed to you, David. If my client's mortgage lender has not supplied a copy of the valuation, how am I supposed to comply with the requirements to confirm that any assumptions may be made by the valuer are correct?
Okay, I assume this is picking up on the comment I made about the Law Society certificate of title, which is embedded into the report entitled "You Send Back to the Lender." That does ask you to confirm that any assumptions made by the valuer are correct, but it does actually specifically say that we are being asked to confirm that any assumptions made by the valuer in any report that we have supplied to you is correct. So if the lender hasn't supplied you with the valuation, then that rather implies that falls away. Well, however, the one thing to watch out for is that sometimes lenders, buried in their small print, will say that we're not going to give you a copy of the valuation. We've given it to our client and to the borrower, and you need to obtain a copy from them. So check the wording of your mortgage instructions carefully. But I think if the lender doesn't supply a valuation to the client or to you, then frankly, as far as I'm concerned, the requirement for you to confirm the assumptions made by the valuer have fallen away, because it does specifically say if we've provided you with a copy of the valuation. So the law certificate of title is frighteningly long. There's an awful lot buried in there that is not really widely appreciated. So read it and be scared is probably the best way of looking at this.
I've always thought there's issues as well with kind of a lot of the Part 2s now, a huge number of the Part 2s dealing with ground rents. Say things like, we'll accept ground rents at 0.1% value on a new build, or that's obviously changed now. 0.2% value on an existing flat is going to be 0.2% of the value of the property, and the value of the property is not the same as the purchase price. Now, do you know what the value of the property is if you've not seen the valuation?
Yeah, indeed. I mean, and lots of vendors, of course, don't do formal valuations. They just do desktop valuations, and or maybe even drive-bys. But I think if you haven't been provided with one, and the client hasn't been provided with one, then I can't see how a lender could hold you to the fact that you're applying assumptions that are in a document that none of you have seen. I mean, I did have one incident recently when I did get a valuation report, and the value, it was an estate rent charge, and the valuer said that he valued it on the assumption that the estate rent charge met the lender's policy. But the lender didn't set out what their policy was, so I had to write to them in great detail, setting out what the rent charge was all about. And inevitably, 3 weeks later, I got a letter back telling me that their requirements in respect of ground rent were set out in a different section of the handbook. So I just trying to go ahead with it anyway. But just if they don't provide it to you, then I'm not sure they've have a great deal of success in claiming that you were in breach of the implied commitment confirmation in the standard report on title.
Richard, any input on that? No.
There's always been a bit of confusion for me that how you're supposed to do these things if you've not seen the valuation report.
Yeah.
And they'll probably have a go at you. They'll try and have a go at you if the worst happens.
Yeah, they will. Yeah, of course they will.
Okay. The next question's for you, Richard. Do you think conservatory questionnaires are a good thing? And if so, what matters should be included?
Yeah, I'm not a great believer in additional inquiries for the sake of it. I do have some time for conservatory questionnaires, and obviously lots of firms use them. If it's a 5th floor flat, I don't think they're a good thing. If you've got a conservatory, it might not be a bad thing. Because I think the TA6 inquiries have obviously got questions about planning permission and likes, and they've got web links and building regs, and they've got web links, to see whether your conservatory needs building regs, because you're always told that conservatories of less than 30 square meters don't need building regs, and there's a lot of exceptions to that. Not least of which there's large numbers of things that call themselves conservatories are not conservatories. Most notably, not uniquely, but most notably when they've taken down the sort of external door between your living room and the conservatory and put an internal door and no door whatsoever. And also things like how it's got a heating system, it must be able to be isolated from the main heating system of the building. And you've also got issues with conservatories, well, you've got houses generally, if they're built within 3 meters of sewers and the likes, then they should have building regs, Part H and drainage and the likes. So I think, if you've got a conservatory, I don't think it's a bad thing. Find out what size the conservatory. You also get surveyors sort of saying things that ask your solicitor if the conservatory needs building regs, as if you're supposed to go round there and measure it up. I mean, that's their job. But
they're the surveyor's just trying to pass the buck there, aren't they? To sort of get the solicitor to confirm something, and we're on the hook, not them. But yeah,
so that's their job, and your job is to get the building regs. But I think things like, is it an external door and the likes between the living room and the conservatory, and it is. I think that's probably legitimate. I don't know what you think about it.
Yeah, I mean, I think it falls into the protocol thing, doesn't it? The inquiry, if it's evident from the buyer's inspection, or capable of being determined by the buyer's inspection, then you shouldn't be raising it as an inquiry. So it's a slightly edge thing. It's clearly down to the the buyer to determine whether there's a conservatory there and to take advice, I would say, from their surveyor. But yeah, and the use of conservatory questionnaires is endemic, isn't it? But whether they're serving any real purpose, well, we'll wait and see. But
if the planning portal was clearer, and if the residential inquiries were clearer, rather than just this sort of statement, conservatories of less than 30 square meters don't need building regs, I'd agree, but you know, they're not that clear. I think they're misleading, quite honestly.
Well, indeed. I mean, it's one of those things that, as you said, I've actually genuinely had, as you said, the inquiry for a conservatory, and it was a third floor flat. So it's just clearly, in some cases, it's properties inquiries are raised by algorithm rather than by human being, and it's just churn out the same. Some
of them raised by human beings are quite bizarre.
Well, indeed, yes, they can be. Yeah.
I got to one. It was please confirm whether the hedgehogs in the garden keep you awake at night.
Did they?
Well, I don't know. I got hedgehogs in the garden here. They're holding all night,
No, it is. I mean, there's tales of all sorts of things, isn't there? But yeah, there we go. Additional inquiries are an art form, shall we say, in terms of drawing stuff out. I mean, I had one recently, about 2 years ago now, where it wasn't additional inquiries, it was ordinary inquiries when the seller, slightly unusual situation, the seller was an executor who had never met the deceased because it was a distant cousin. And so he'd never met the deceased, he'd never been to the property, and so he was unable to answer any inquiries. And the buyer solicitor just kept saying, I must have replies. So we replied to every inquiry saying, the seller has never met the deceased, has never visited the property, has no information, and cannot answer your inquiry. And answered every inquiry in that way, and they then backed down and accepted it. So you think, well, all a bit of a farce, really, wasn't it? So.
My best, I mean, you know that you've heard this before. My best ever was the one in Cornwall with the radon gas. Would you please provide the address of the supplier of the radon gas? Who
supplies the radon gas? Yeah, so who supplies the radon gas? Well, God is the answer, isn't it? So,
yeah, that was the answer that was given.
Well, the Smuggler's Cottage one, I think, wasn't it? Has there ever been any criminal activity at the property? Yeah.
Yes,
it's called Smuggler's Cottage.
It's 400-year-old property, Smuggler's Cottage.
Okay. Moving on, possibly the last question directed to you, David. My client is buying a lease with the rent review, where the rent review is linked to RPI. The reviews are every 5 years. Is this a problem?
Okay. Well, I mean, the part one basics here says that lenders don't have any objection to rent reviews periodically, and they say they don't have a problem with them being linked to RPI. Now, whether that will change, given if RPI is running at 11-12%, then they might adjust that. But at the moment, if it's simply linked to RPI, then on the face of it, lenders say they're not concerned. They do say, however, that they're concerned about unreasonable frequencies or unreasonable multipliers of 5, 10, 15 years or so. And if you're not sure about it, refer it. So, in fact, the fact that it's RPI isn't a problem. The fact that it's every 5 years might be a problem. So I'd err on the side of reporting it, and you'll get the left thing back from the lender saying we rely on you to protect our security, but at least you've reported it and told them. So it sort of falls between two stools to some extent. But I would say, the RPI bit's not a problem. The 5 year bit, marginally an issue to be looked at, I suspect.
I am amazed how some mortgages in their part twos are still saying, we've got no objections to RPI increase.
Yeah.
Because I would be so careful vis-a-vis the client on those. Because I can see a situation in the next few months where mortgagees start saying we won't accept RPI.
Yeah, because it's going to be so high. And it's, I mean, when I did a session on it recently for the solicitors group, I did mention that that they accept them at the moment, but RPI is running at 11%, so 12%, 13%, whatever it is. I haven't looked at the RPI for the last 20 minutes. I don't know what's happened to interest rates and the rest of it in the last half an hour. So, but essentially, inflation is back, isn't it? So yeah, there might have to be a readjustment of some of those.
I'd be very careful at the moment with RPI.
Yeah.
If the mortgagee says we don't want to know about it, fine, but
Yeah.
the client comes to sell a year from now, who knows?
Yeah.
I have heard the litigators are rubbing their hands with glee on that one.
I did. I mean, I suppose the other issue is that the SRA guidance note on leases basically makes it clear we have to make clients aware of the exponential effect of rent review clauses. So if you have got an RPI linked clause, be very, very careful to make sure you've explained it in detail to the client, and that RPI is not the cuddly little thing that it used to be. It's rampaging away.
Mm-hmm.
Okay. Well, unfortunately, that's all we have time for today. So thank you for attending Law 2022 Online, Residential Property by Shape the Debate, hosted by Move Reports. Thank you to our expert speakers, David Keeley and Richard Snape. And don't forget to join the Solicitors Group Law 2022 Online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to watch the pre-recorded content. Your expiry dates will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you'll also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue, worth £35 plus VAT. You can also visit our exhibitor profile for more information on our family wizard. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD